You guys are now all streaming, so be on your best behavior. Hello. We're just waiting for one more juror and then we can get started. All right, keep hanging tight. We're waiting for one more juror who I'm told is on her way virtually. So, all right, here we go. All right, now that we have everyone here, I'm just going to get clearance from the competition before we start. Jordan from the prosecution. Can you just pronounce your last name for me?
Sure, it's Hulsberg.
Hulsberg with a B?
Yeah,
Okay.
Hulseberg.
Okay. Thank you.
Sure.
And Mackenzie for the prosecution. Can you just pronounce your last name for me?
Yes, ma'am. And it's going to sound as crazy as it looks. So it's going to be EHRHAR. D is in David, T is in Tom.
How do you pronounce that?
Earhart, like Amelia.
Earhart. Okay. Thank you.
We're the team with difficult last names.
I've encountered more difficult last names, so this isn't too bad. Too out of my wheelhouse here. All right, guys, we're just waiting for clearance. Thanks for your patience. Okay. Everyone is here and we just received the message to get started. So let's call the case of State of West Carolina versus Timothy Ray. My name is Judge Ambrose. Scoring judges, please look to the two buttons on the lower left of your screen and turn off your audio and video. These should remain off until the trial ends. You should also have your video set to hide all non-video participants. This means that the only people on the screen right now should be the advocates and myself. Okay, so I'm still seeing other people on my screen. Or can someone tell me, are you in gallery view and can you see all the participants on the screen?
Yes,
No, ma'am,
yes, Your Honor. I think if you want to get rid of the other participants who don't have their screen up, you have to select hide non-video participants.
Okay. I have to select non-view non-party participants.
Correct, Your Honor.
Oh boy. Any idea where I can find that?
Yes, ma'am. If you go down to the stop video icon that you see there,
Mm-hmm.
click that little arrow,
Yes.
it'll bring up the video settings for you.
Ah, there we go.
If you go down to, I believe, video, and then you go towards the bottom of that little screen, there'll be a little checkbox that says hide non-video participants.
Okay, here we go. All right, now we should be good. Here is myself and here are my two advocates. Okay, awesome. Okay. Can the attorneys please make appearances for the record?
Good afternoon, Your Honor. My name is Mackenzie Earhart, and I'm here along with my co-counsel.
Good afternoon, Your Honor. My name is Jordan Holsberg. I believe we already spelled our names for you. And we are here on behalf of the government. We are team number 101.
And Your Honor, once defense has made their appearances, we have a few housekeeping matters as well as a few substantive matters we'd like to address.
Okay, sure thing. But we'll switch over to defense if you can make appearances.
hello, Your Honor. My name is Malcolm Mills. Last name spelled M-I-L-L-S for Team 103, here on the behalf of the defendant.
Good afternoon, Your Honor. Danielle Rivera, last name spelled R-I-V-E-R-A, here also on behalf of the defendant, Timothy Ray. And when Your Honor is ready, we also have some stipulations to address with the court, as well as housekeeping.
All right, I'll switch back to the prosecution. Prosecution, you want some housekeeping matters to address?
Yes, Your Honor. May we move about our personal wells freely for closing arguments, opening statements, and examinations?
Yes, you may.
May we assume that the witnesses are pre-sworn?
Yes.
Your Honor, we wish to invoke the rule of sequestration pursuant to Federal Rule of Evidence 615. We understand that there are experts in this case and may be permitted, but we would ask that the other fact witnesses are excluded.
Any objection from the prosecution? Or I'm sorry, from the defense?
We have no objection, Your Honor.
Okay, they will be sequestered.
Your Honor, when we would like to be heard outside the presence of the jury, how do you prefer we do that? A constructive sidebar, asking to approach?
We can presume that all objections will be heard outside the presence of the jury, so no need to ask to be heard outside the presence of the jury.
Thank you, Your Honor. May we retain the pre-markings of the exhibits in this case? They are joint exhibits, and I believe from discussions with opposing counsel, they have no objection to that.
Is that true, defense?
That's correct, Your Honor.
Okay, no problem.
And lastly, Your Honor, pursuant to the procedural rules of this jurisdiction, we just wanted to make sure that it was appropriate for us to refer to an exhibit with a case notebook number For example, when we would like to publish something or direct a witness to that, may we just refer to what page number that casebook is as well as what the exhibit number is.
Yes, that's fine.
And Your Honor, we have a few stipulations as the defense mentioned earlier. Would you prefer we discuss those now, or would you prefer we wait until substantive matters?
I am going to flip over to the defense to see if they have any housekeeping matters first. Defense?
Yes, Your Honor. Would Your Honor prefer that we formally tender our expert witnesses in this case?
Yes.
And may we be permitted to remain seated for objection so that we could stay within our camera frames?
Yes.
And with that, Your Honor, we have no other housekeeping matters. We're ready for trial.
Okay. Let's address the stipulations that prosecution was referring to.
Yes, Your Honor. In speaking with opposing counsel beforehand, we've agreed to several exhibits. Would you like me to go ahead and read those off for you?
Go ahead.
Yes, Your Honor. That is going to be Exhibit 6, 7, 17A, 17B, 22, and 27. And Your Honor, we would also like to make sure that these are admitted pre-trial.
Okay. Is that a stipulation that you came to with the defense in your pretrial meeting?
Yes, Your Honor.
Defense, do you so stipulate?
Yes, Your Honor.
Okay.
And then, Your Honor, we have one more stipulation with opposing counsel beforehand, which was that we have agreed to have constructively identified the defendant in this case.
Okay. So stipulated defense?
Yes, Your Honor.
And Your Honor, if we may, we have one substantive motion that the prosecution would like to present to the court.
Go ahead.
Your Honor, the government is moving to exclude the deposition testimony of a Dr. Samantha DiGiuseppe. We are moving to exclude this testimony on 3 grounds. The first is that it would be an improper expert opinion. The second is under the best evidence rule. And lastly, it will be under 403 grounds. Now, to give you a little bit of context, Your Honor, the prosecution has charged the defendant in this case with first-degree murder. The defense is asserting an affirmative defense of insanity. We're going to hear from 2 experts today that will discuss mental health conditions and mental illnesses. Dr. DiGiuseppe is not a mental health professional, and this testimony, again, as mentioned before, should be excluded for a few reasons. The first is that it will be an improper opinion. Dr. DiGiuseppe is not a psychiatrist. She provided a deposition in this case that only spoke to the primary care of the defendant in this case, and to her own admission in the deposition says she is not qualified to address mental illnesses. Additionally, Your Honor, under the best evidence rule, Dr. DiGiuseppe has admitted she doesn't have the health records for Timothy Ray, for the defendant in this case. They were lost. So her testimony is only relied on by her own memory. The only things that she has discussed or has discussed during the deposition were based off of her memory, which admittedly, she could not remember certain dates, couldn't remember certain years. And because we don't have the best evidence in this particular case, which would be those medical records, this testimony should also be excluded. Lastly, Your Honor, on the last grounds, we would move to exclude any of this testimony would be under Federal Rule of Evidence 403. The likelihood that the prejudicial effect of the evidence that would be presented would greatly outweigh any probative value. What this would be doing is using Dr. DiGiuseppe's testimony through the mouthpiece of an expert, which would be both misleading and confusing to jurors. And for those reasons, Your Honor, we move to exclude any of Dr. DiGiuseppe's testimony.
Thank you. Defense, any response for that?
Yes, Your Honor. To the prosecution's first point, we do not intend to elicit any testimony regarding a mental diagnosis that Dr. DiGiuseppe gave. Simply, the testimony that we intend to elicit is regarding the conduct of Mr. Ray during his appointments with Dr. DiGiuseppe. And according to the advisory committee notes, even a layperson can testify to a person's manner of conduct. And so we are not using that testimony or we don't intend to elicit a diagnosis or any sort of medical terms from her testimony. Simply the conduct, which is the circumstantial evidence of Mr. Ray's state of mind and schizophrenia. Additionally, to the best evidence and the health records, Your Honor, that argument goes to the weight of the evidence and not the admissibility. Dr. DiGiuseppe's testimony was done during a lawful deposition where the prosecution had the opportunity to cross-examine her. And our expert, as well as the prosecution's expert, bases their opinion on this testimony. And as far as the prejudicial effect, Your Honor, the probative value of this evidence substantially outweighs its prejudicial effect. Both experts relied on this testimony in coming to their opinions in this case. And the jury should be allowed to hear the basis of both experts' opinions when coming to their decision.
With hearing both arguments, I'm going to deny prosecution's motion excluding the deposition of Dr. DiGiuseppe. Prosecution, do you have any more motions in limine?
That concludes our substantive motions, Your Honor.
Defense, do you have any motions in limine?
Your Honor, we do not have any motions, but there are two stipulations we would like to address with the court. Both parties stipulated that neither expert will testify as to the ultimate issue being whether Mr. Ray understood right from wrong on the day he killed Nathan.
So stipulated, prosecution?
That's correct, Your Honor.
Okay.
And the second stipulation that we have reached is that Dr. LaGreca will not testify to 1 in 5 people being psychologically evaluated in the context of a criminal case, specifically 1 in 5 people malingering.
So stipulated, prosecution?
That is correct, Your Honor.
Okay. Your stipulations are noted for the record. Prosecution, are you ready to proceed?
Yes, Your Honor.
Okay. We will now hear opening statements from each party. Everyone should make sure that they are in speaker view. That button is in the upper right of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. Prosecution, whenever you're ready.
Your Honor, before I proceed, I just wanted to do a quick technical check. Are you able to see and hear me all right?
Yes, I am.
Excellent. Permission to proceed.
Yes.
Fight or flight. It's our basic instinct. It's raw, it's fear, it's life or death. But there's a third choice, and you'll learn about it today. It's the choice the defendant made. Fake it. You'll learn the defendant was stopped at a routine DUI checkpoint 2 days after he killed his son, Nathan, just after he buried the 6-year-old's body. A shovel, large garbage bags, and bleach were even still in the car, and they were all seen by the officer. Too weak to fight and too slow for flight, the defendant chose to fake a mental illness. And I'll say that again. You'll learn today that the defendant killed his son, and now, after being caught red-handed, wants you to believe he's not responsible because he suddenly has a mental illness. Well, after you hear what the facts say and what our expert says, you'll know who was responsible. Here's what the facts say. You'll learn that just before the defendant strangled his son, his ex-wife dropped Nathan off at the defendant's home. The two were separated and feuding after the wife's recent affair came to light. And she was panicked when she went to pick up her son from school 2 days later, and he wasn't there. Instead, Nathan's teacher told her that the 6-year-old hadn't been to school for the past 2 days. Who was responsible for Nathan those past 2 days? The defendant. The defendant was the one responsible. In fact, the evidence will show that while Nathan was spending a few days with the defendant, he spilled some apple juice on his dad's work laptop. And the defendant raises his voice and begins screaming at his 6-year-old son. He screams to the point that Nathan flees to his room. And the defendant, he chases him in there. And when he arrives to his crying son, he screams at him some more, but too much was never enough for the defendant. He screams at Nathan, but it wasn't enough. He orders him to do jumping jacks, but it wasn't enough. He orders him to do high knees, and it still wasn't enough. You'll learn that no punishment was enough for the defendant. And so the defendant went to his bedroom and grabbed his belt. But before he did, he sat down on his bed to try and calm down. But he chose to continue. And after he made that choice, he went back to Nathan's room, belt in hand. And when he arrived to his crying son, he screamed at him some more. And you gotta wonder what was going through the mind of a 6-year-old boy, not understanding what he did to deserve this. And in his last few moments, Nathan fought back and screamed, "I hate you." And the defendant wrapped the belt around Nathan's neck and pulled it tight. Pulled it until Nathan stopped screaming. Pulled it until Nathan stopped kicking. Pulled it until the blood vessels in Nathan's eyes burst. And Nathan's last few seconds alive were spent begging, "Please, I want my mom. Please, I want my mom." And we know all of this, all the gritty details, because they came straight out of the defendant's mouth. He confessed every word to police. And you know what? You'll learn that everything was found exactly where the defendant said it would be. The police found Nathan's body exactly where the defendant said he buried it. The police found spilled juice on the counter exactly where the defendant said everything started. The police even found a belt in Nathan's room exactly where the defendant said he strangled him. The defendant didn't shoot Nathan. He didn't stab him. He didn't kill him instantly. He took the time to strangle him. He took the time. And so we have charged the defendant with first-degree murder. For this charge, we must prove 2 things. First, the defendant intentionally killed his son, Nathan. And second, that killing was done with premeditation, that it was planned, that it was done with a heartless aspect to it, or it was done without care to Nathan's life. And because we're bringing the charges today, we have the burden to prove them. And we have to prove it beyond a reasonable doubt. Now, beyond a reasonable doubt doesn't mean beyond all possible doubt, just reasonable doubt. But the defense also has a burden today. Because the defendant is pleading insanity, they need to prove through clear and convincing evidence that the defendant either didn't know right from wrong or didn't understand what he was doing when he killed his son, Nathan. Now, it's not just any mental illness that the defendant claims to have. It's schizophrenia. And you will learn that schizophrenia is a serious and debilitating mental illness that can trick the mind into thinking things are there. Now, you may want to believe or even hope that the defendant has schizophrenia because no reasonable, right-in-the-head loving parent could do this to their own child. Just remember, murdering your son is always senseless, but that doesn't mean the murder is. It was a senseless crime, but not a senseless man. And luckily, in this case, we have an expert witness to help you understand what schizophrenia is and why we know the defendant doesn't have it. Here's what the expert says. You'll learn that after looking over all of the evidence in this case, over 100 pages worth, that Dr. McLaGreca, who has practiced psychiatry for nearly 3 decades, came to a conclusion that he was certain about. The defendant showed strong signs of malingering. And Dr. LaGreca will explain that malingering is a big word with a simple meaning. Faking. It means faking. And the facts will show the defendant was pulled over for a routine DUI stop. He spoke with the police, looked them in the eye, and answered their questions. But the moment the police looked in the back seat, the moment they see a shovel, bleach, and large garbage bags, the moment he was caught, that's the moment the defendant suddenly had schizophrenia. And the evidence will show there's no real history of schizophrenia either. The defendant had never told a doctor about it before. The defendant had never been treated with it before. The defendant had never been hospitalized with it before. The defendant had never even been diagnosed with it before. In fact, the first real signs of schizophrenia showed up after the defendant was stopped. Fight, flight, or fake it. The defendant chose fake it. Murdering your son is always senseless, but that doesn't mean the murderer is. It was a senseless crime, but not a senseless man. The facts say so, and the expert says so. And at the end of this trial, my co-counsel will ask you to return the only just verdict, a verdict that holds the defendant responsible no matter how hard he tries to get out of it. A verdict of guilty.
Thank you, Mr. Holzberg. Mr. Mills, opening statement whenever you're ready.
Yes, Your Honor. Members of the jury, there's no way to remove the shock, the pain, and the disbelief all of us feel about Nathan Ray's death. But it's not enough for us to look at how it happened. We must also look at why. And that's complicated. Timothy Ray isn't here to dispute that he killed Nathan Ray, that he drove around with his son's body for days trying to decide what to do, or that he buried his son in a grave in the park. But the answer to that other question, the why behind the what, well, he was following the voices. Voices he's heard for years, troubling him with delusions that his wife and son were plotting and scheming against him, tormenting him with hallucinations that his wife and child wanted to kill and eat him, trapping him by insisting that Nathan needed to be punished. Members of the jury, Mr. Ray has been trapped for years by schizophrenia, in a mind he can't trust to tell him what's real and what isn't. And for Mr. Ray, there's no escaping that trap. Today, the prosecution must prove beyond a reasonable doubt that Mr. Ray killed Nathan. And like I said, we're not here to just convince you that he didn't. Instead, we're here to prove to you why Timothy Ray should be found not guilty by reason of insanity. After you hear the evidence presented today, two things will be clear. First, Mr. Ray was suffering from schizophrenia on October 17th, 2018. And second, Mr. Ray's schizophrenia stopped him from understanding the wrongfulness of his actions. So let's take a look at the first thing that the evidence will show, that Timothy Ray was suffering from schizophrenia the day Nathan died. But to understand that, we have to go back to Mr. Ray's childhood. See, from the moment he was born, Timothy Ray was set to develop a mental illness. Mr. Ray's mother was cruel and abusive, refusing to feed him, leaving him in cold baths for hours, and eventually abandoning him when he was 3. He began hearing voices at 10 and seeing hallucinations by the time he was 23. And by 2017, the year before Nathan's death, Mr. Ray's ex-wife and primary care doctor were worried about his mental health. You'll hear from Dr. Shane Riley, a forensic psychiatrist with over 20 years of experience diagnosing and treating people with mental disorders. Dr. Riley will tell you that the symptoms Mr. Ray was suffering from, hearing voices, delusions, drastic mood swings, they're all common signs of schizophrenia, a mental disease that can make it difficult or even impossible for people to maintain their connection with reality. And this takes us to the second thing that the evidence will show, that Timothy Ray's schizophrenia prevented him from understanding the wrongfulness of his actions. You'll hear about what happened when Mr. Ray was pulled over after killing his son. Officer Peyton Wentz will tell you that the night he was stopped, Officer Wentz will tell you that the night she stopped Timothy Ray at a DUI checkpoint, she knew something was off right away. He was frantic. He reeked body odor. And he accused Officer Wentz of being in the CIA. He got out of his car and began doing jumping jacks in the middle of the street. And he didn't stop even when Officer Wentz pulled her gun. When Detective Booth, the detective assigned to investigate Nathan's disappearance and death, showed up at the checkpoint, Officer Wentz made a point of telling him about Mr. Ray's strange behavior. But Detective Booth will be forced to admit that despite the information Officer Wentz provided, she didn't spend much time looking into why Timothy Ray killed his son once he admitted what he'd done. She completely disregarded Mr. Ray's statements about the voices that told him his wife and son were plotting against him and that they told him to punish Nathan. And despite Mr. Ray's erratic behavior in the interview room, despite being told that Mr. Ray was acting crazy at the traffic stop, despite Mr. Ray insisting that Detective Booth was a CIA agent, Detective Booth never followed up on Mr. Ray's mental state. There was a video recording of that interview that would allow anyone watching it to both hear and see exactly how Mr. Ray was acting. But you won't get to see that recording because Detective Booth decided not to save it, deciding that a transcript was enough. And as a result, you'll read, but you won't be able to see, Mr. Ray begging Detective Booth for help, or Detective Booth responding by saying, "You're a piece of shit, Tim. You'd be better off dead." And why did Detective Booth react like this? Because while she may be a good, objective investigator in many cases, this case was different. In this case, Detective Booth both knew the suspect and the victim. You see, Detective Booth's child and Nathan Ray were teammates on the same soccer team. Members of the jury, there is nothing easy about this case. But at the end of this trial, it will be clear that Mr. Ray is not a depraved killer. He is a man troubled, tormented, and trapped in a mind he can't trust. That is why at the end of this trial, my co-counsel will ask you to return the only fair verdict, the only just verdict, and the only verdict supported by the evidence, that Mr. Ray is not guilty by reason of insanity.
Thank you, Mr. Mills. Before the state calls its first witness, I will ask everyone to switch to gallery view. That button is in the upper right of your screen. This will allow you to see the attorneys and witness at the same time. All right, prosecution, go ahead and call your first witness.
Thank you, Your Honor. Prosecution calls Detective Booth to the stand.
All right, Detective Booth, you are constructively sworn in. Whenever you're ready.
Thank you, Your Honor. Good afternoon. Could you please introduce yourself to the jury?
Good afternoon. My name is Detective Blake Booth. I'm from the Skelton Police Department.
And how long have you worked for the Skelton Police Department?
I've worked for a total of 23 years. I started off in the violence and narcotics unit as an officer, and then I changed over as a detective. And up until 3 years ago, I moved over to homicide.
Now, how many homicides have you investigated, Detective Booth?
I've investigated a total of 12 homicides and I've been the lead in 4.
Why are you here testifying today, Detective Booth?
I'm testifying today because I was the lead investigator in the killing of Nathan Ray.
Now, how exactly did you get involved in the case?
I first got involved because a missing persons report was filed by the victim's mother, Jessica Ray, and we put out a BOLO for the defendant, which means to be on the lookout, and that's how I got involved.
Your Honor, I would like to direct the court's attention to page 54 of the case notebook, what has been marked as Exhibit 7 and entered into evidence. Do I have permission to publish that?
You do. Just one brief second, though. Whoever from the defense is going to be crossing. There we go. Okay. You can go ahead and publish. Yes.
Thank you, Your Honor. Detective Booth, do you have Exhibit 7 in front of you there?
Yes, ma'am.
Now, why did Jessica Ray file this missing persons report?
Well, as you can see by the narrative of the report, Jessica Ray and Timothy Ray were in less than amicable conditions with each other, and she had last seen the victim, Nathan Ray, with the defendant. She hadn't seen him in 2 days, and the defendant was not communicating with her. She couldn't get a hold of him, and she became very concerned. So she filed that report.
Thank you, Detective Booth. Now, what exactly happened once you got to that sobriety checkpoint that you mentioned?
So, like I said, we had put out a BOLO for the defendant, and when he got stopped at the sobriety checkpoint, they ran his license plates, and I got called over to the scene. I arrived to the scene. I was able to examine the defendant's car. I saw some concerning burial tools in the back of his car, and I also spoke to the defendant when I arrived.
You gave us a lot there, Detective Booth. Let's talk about what you saw in the car first. Can you describe exactly what you saw?
Yes, ma'am. Like I said, I saw some burial tools that became a bit of a concern, and it was a shovel, Clorox bleach, and some trash bags.
Your Honor, directing the court to page 99 of the case notebook, I'd like to publish what has been entered into evidence as Exhibit 22. Do I have permission to do so?
Yes, you do.
And Detective Booth, can you tell us exactly what you saw at that scene?
Yes, ma'am. This is one of the pictures that I took from the defendant's car after we were able to get a warrant. And this is exactly what I saw when I was able to arrive at the scene. Like I mentioned, the shovel is right there, the Clorox bleach bottles, and right there in the corner, you can see the packet of black trash bags.
Thank you, Detective Booth. Now, you also mentioned at the sobriety checkpoint that you'd spoken to the defendant. What was that conversation like?
When I arrived, I approached the defendant and I told him that we would be taking him over to the station. He then said, "I understand. I will tell you everything."
And what happened once you left the checkpoint and got down to the police station?
Once we got over to the police station, I began the interview process with the defendant. That was when he confessed to killing his 6-year-old son.
How did the defendant kill his son?
He started by saying that they were at their home and that it was October 17th. He said that Nathan accidentally spilled some juice over on his laptop when they were getting ready for work. Later, the defendant got very agitated because of that and began a series of punishments because of the spilled juice. He mentioned that he yelled at Nathan. He made him do some physical exercises, jumping jacks, high knees, running in place. Eventually, that wasn't enough, and the defendant went back to his room, grabbed a belt, hit Nathan with it, and eventually strangled him with the belt.
We're going to break that down a little bit, Detective Booth, but can you tell us exactly where the defendant's home is?
Oh, yes. It's right here in Skelton, over by Conway Street.
Okay, now, did the defendant say how long he made Nathan do the exercises?
He did not say how long it was. But like I mentioned, he kept asking Nathan to do them. And at some point, he said that Nathan was not doing them right. And he went back to his room to grab a belt and continue a different series of punishment.
Now, Detective Booth, you did mention that the defendant admitted to using a belt to strangle Nathan, but did he tell you what he'd done with the body?
He mentioned that he buried it in the woods by Brandywine State Park by 22. We were able to confirm that by sending a team there, and we found the body there.
Now, once you'd uncovered Nathan's body, was there ever an autopsy report done?
Yes, ma'am, that is standard procedure. A medical examiner later made a report according to that autopsy, and I was able to review that.
Your Honor, directing the court and this witness to page 53 of the case notebook to what has been marked as Exhibit 6 and entered into evidence. Do I have permission to publish that?
Yes, and moving forward for all parties, anytime an exhibit is entered into evidence, you can go ahead and share your screen. You do not need to ask for permission.
Thank you, Your Honor. Detective Booth, do you have Exhibit 6 in front of you there?
Yes, ma'am.
What is it?
That is the medical examiner report that I was able to review after the autopsy of Nathan Ray.
And how is this helpful in your investigation?
Well, as you can see by the second line in the report, the doctor said that the manner of death was asphyxiation and that the cause of death was homicide. That was especially significant because it was consistent with the story of the defendant at the station, saying that he used a belt to be able to strangle Nathan with.
And did you ever find any instrumentality that was consistent with causing strangulation?
Yes, ma'am. After we were able to search the house of the defendant, once we got a warrant, and we were able to find a belt at Nathan's bedroom, again, consistent with the confession at the station.
Detective Booth, you should have Exhibit 27 there in front of you. What is it?
That is one of the photos that I took when I was in the search of the house, specifically the belt as we found it in Nathan's bedroom.
Now, Detective Booth, at the conclusion of your investigation, were there any other suspects that could have killed Nathan Ray?
No, ma'am. After the confession of the defendant himself, the evidence at the house, the belt, the burial tools in his car, the confirmation of the body exactly where the defendant said it was, there was no other suspect.
Thank you, Detective Booth. I have no further questions for you at this time.
Ms. Rivera, do you have a cross-examination?
Yes, Your Honor.
Whenever you're ready.
You knew Mr. Ray before this investigation, hadn't you?
Yes, ma'am. Our kids played soccer together, so I had seen him at practices before.
That's right. So you saw Mr. Ray at practices and games.
Yes.
And it had to be concerning when you learned that Mr. Ray's son, Nathan, was missing,
Yes.
and that Mr. Ray was suspected of taking the boy.
I mean, he was the last person seen with Nathan.
Perhaps my question wasn't clear. It was concerning when you learned that Mr. Ray was suspected of taking the boy.
Oh, yes, ma'am.
When you got down to the checkpoint where Mr. Ray was stopped, you spoke with Officer Wentz.
Yes, ma'am. I asked Officer Wentz, since he was the first person to handle the situation, to try to get me in the loop.
Officer Wentz, like you said, was the person who stopped Mr. Ray.
Yes.
Officer Wentz told you that Mr. Ray was, quote, acting crazy.
Objection, Your Honor. Calls for hearsay.
Did you say hearsay?
Yes, Your Honor.
Response?
Your Honor, we are not using this for the truth of the matter asserted, but to simply show that Detective Booth was put on notice that there was something wrong with Mr. Ray that required her to investigate further.
Prosecution, do you have anything based on that response?
Your Honor, if that is what the testimony is being elicited for, that we have no issue with that. However, we would ask for a limiting instruction to the jurors to understand that it is not being offered for its truth.
Okay, based on that, I will provide the members of a jury with a limiting instruction when it's appropriate. The objection's overruled.
Detective Booth, Officer Wentz told you that Mr. Ray was, quote, acting crazy.
He did mention that.
So crazy, she felt he needed medical attention.
Yes, she did mention that.
Now, Officer Wentz also told you about the several items in the back of Mr. Ray's car.
Yes, and I was able to take a look at them.
That was the shovel.
Yes, and the Clorox bleach and the trash bags.
Knowing that Mr. Ray's son was missing, those items had to make you suspicious.
Of course, those are typically burial tools. So like I said, it was pretty concerning.
So concerning that you took Mr. Ray down to the police station.
Yes, ma'am.
And it was during that interview where you learned that your child's teammate was dead.
Yes, ma'am. The defendant confessed to that.
That had to be hard for you.
Yes, ma'am.
In fact, you lost your temper during your interview with Mr. Ray.
I did at some point.
You called Mr. Ray a, quote, piece of shit,
Yes, ma'am. I did say that.
and said he'd be better off dead.
Yes, ma'am. I did say that.
You'd agree your judgment was a little clouded in this case.
I wouldn't say my judgment was clouded. I got upset at the knowledge that a father killed his own son, but I handled this investigation just like I would handle any other investigation.
Well, it is fair to say that Mr. Ray made some unusual statements during your interview.
I don't know what you mean by that.
Well, he asked you if you were in the CIA,
He did say that at some point.
and he mentioned hearing voices the morning he killed Nathan.
He didn't say voices. He kept saying using the pronoun they.
Specifically, he said, quote, they told him Nathan's mother tricked Nathan into spilling the juice,
Yes, he did say that.
and that they told him Nathan needed to understand he couldn't let his mother trick him.
Yes, he did say that.
Mr. Ray actually used that word they repeatedly,
Yes, he used it constantly.
but you never asked Mr. Ray who they were, did you?
I did not. I did not think much of it. I kept going on with the interview as I would.
Now, after you found Nathan's body, you spoke with Nathan's mother, Jessica Ray.
I did speak with Jessica Ray after that. It was a pretty tough call.
Mrs. Ray told you that she should have never left Nathan alone with Mr. Ray when he was acting strange.
Objection, Your Honor. Calls for hearsay.
Response?
Your Honor, this statement falls under the excited utterance exception, as this statement was made while Mrs. Ray was in the excited state of finding out that her only son was dead and found.
Do you have a response to that, prosecution?
Yes, Your Honor. This is not an excited utterance. This is merely this is being used as an excited utterance here. But we do not believe that it's relevant at this point. We would actually like to change our objection now as to how exactly this is relevant.
Ms. Rivera, responding to the relevance?
Yes, Your Honor. This is relevant because it goes to Detective Booth's credibility and how she investigated this case. And finding this statement out from Mrs. Ray and still not continuing to investigate further is directly relevant to her credibility and how she handled the case.
Is the defense critical of the investigation that Detective Booth conducted?
Your Honor, it's our theory of the case that Detective Booth had a bias while investigating this case because of her personal connection to the victim and the defendant. And so we believe that her bias clouded her judgment.
Your Honor, if I may.
Sure, go ahead.
The prosecution still contends that this is not relevant. Additionally, to the excited utterance objection, defense counsel hasn't laid the foundation that this was an excited utterance statement.
Okay, what I'm going to do is I am going to sustain the objection. Ms. Rivera, if you can please move on.
Yes, Your Honor. Mrs. Ray also said that she knew Mr. Ray was going crazy.
Objection, Your Honor.
Sustained.
When you talked to Mrs. Ray, you never asked her any questions about Mr. Ray's past mental health.
No, ma'am, I'm not a doctor. I'm here to collect evidence.
But you are an investigator in this case.
I am. I'm the lead investigator in this case.
And as the lead investigator, it is your job to collect all of the evidence.
Yes, ma'am.
And that's evidence of guilt,
Yes, ma'am.
as well as evidence of innocence.
I collect all of the evidence.
But you never questioned Mrs. Ray about Mr. Ray's mental health history.
No, like I said, I'm not a doctor, and I was just there to inform Jessica Ray of what happened.
Well, as an experienced homicide detective, it's important to know whether a suspect is mentally ill.
I agree.
You know that in certain cases, mental illness can be a defense to crimes.
Yes, ma'am.
Now, Skelton Police Department has specific directives for collecting evidence.
Yes, ma'am.
Directives say that all interviews should be recorded on video.
Yes, ma'am. And this interview was?
That's right. But you never saved that interview recording with Mr. Ray.
Well, the way that our process of collecting information works is that interviews are retained for 30 days, and unless a request is submitted, then it automatically gets deleted by the system.
And to make that request, all you had to do was send over that request to the IT department.
Well, I had to follow all of the necessary procedures, but to be able to preserve it, yes, I needed to submit a formal request.
And you had 30 days to make that request.
Yes, ma'am.
But like you said, you didn't preserve it.
No, ma'am. There was a transcript of the defendant confessing to the killing in a very detailed manner, so I didn't feel a need to.
And because you didn't feel the need to save that recording, we can't see Mr. Ray's demeanor when he asked if you were in the CIA.
No, ma'am.
We can't see his demeanor when he talked about the voices he said he was hearing.
No, ma'am.
We also can't see how angry you were when you called Mr. Ray a piece of shit.
You can read it in the transcript.
Your Honor, no further questions.
Ms. Earhart, any redirect?
No, Your Honor, no redirect for this witness. We only ask that she be excused.
Yep, she may be excused. Prosecution, do you have any more witnesses?
Yes, Your Honor. We call Dr. Mac LaGreca.
All right, Dr. LaGreca, and Ms. Earhart, if you could just turn your video off. All right, Dr. LaGreca, you are sworn in.
Hello.
Hi, Dr. LaGreca. How are you?
I'm good. I'm good. How are you?
Excellent. Thank you. Dr. LaGreca, let's get right into it. Why are you here today?
I'm here to serve as a medical expert in this case.
All right. So let's talk a little bit about your qualifications. What's your job right now?
Currently, I am the program director, helping train future psychiatrists to become forensic psychiatrists. I also help teach at the local hospital and as well serve as medical experts in legal cases such as these.
So before we get into what your average day looks like, you mentioned forensic psychiatry.
Yes.
What is that?
Forensic psychiatry is like the intersection between psychiatry and the law.
All right. So let's get into what your average day looks like.
Sure. My average day involves helping students learn and teach them about forensic psychiatry, as well as helping serve on cases like these.
Where did you go to medical school?
I went to medical school in the University of Pennsylvania Perelman School of Medicine.
And then after graduating from UPenn, did you do any additional training?
Yes, I went to University of Los Angeles for my my 4-year degree in psychiatry, general psychiatry, and then I went back to my University of Pennsylvania for my residency in forensic psychiatry. I am board certified in both general psychiatry and forensic psychiatry.
What does that mean to be board certified?
It's basically a certification suggesting that I took the test and passed the required basic knowledge to practice in that field.
So how long in total have you been practicing as a forensic psychiatrist?
It's been around 30 years.
And during those 30 years, what kinds of mental illnesses have you treated?
A whole wide variety of ranges, from depression all the way to schizophrenia, malingering, all of them.
So schizophrenia is an issue in today's case. About how many times have you treated with a patient with schizophrenia, excuse me?
Schizophrenia? Oh,
Yeah.
It's probably in the hundreds. I couldn't keep track of all that.
I understand. Have you ever been an expert witness before?
Yes, in 7 cases.
Were any of those criminal cases?
Yes, one was.
And as an expert, have you testified about schizophrenia before?
Yes, I have.
Your Honor, at this time, the prosecution tenders Dr. McLaGreca as an expert in forensic psychiatry and the diagnosis of schizophrenia.
Any objection?
We have no objection, Your Honor.
All right, will be tendered.
All right, Dr. LaGreca, were you able to reach any conclusions in this case?
Yes, I was.
And do you hold your conclusions to a reasonable degree of medical certainty?
Yes, I do.
What are your conclusions?
My conclusions is that the defendant did not suffer from schizophrenia, nor did he ever suffer from schizophrenia, and in fact that he is malingering.
What is that word, schizophrenia?
Schizophrenia, by definition, according to the DSM-5, is a psychiatric illness which affects the mind. Affects about approximately around 1% of the population, and essentially they have a whole list of symptoms from delusions, hallucinations, negative symptoms, and a bunch of other things going on too. Yeah.
You mentioned another word. What is malingering?
Malingering, according to the DSM-5, is essentially faking an illness for some sort of gains, personal gains for the person faking it. Usually that is usually in the case of getting money, financial compensation, getting out of trouble, trying to get something, getting drugs, those kinds of things.
You mentioned it a couple of times. What is the DSM-5?
The DSM-5 is the gold standard for psychiatry and general psychiatry and forensic psychiatry. It's what every psychiatrist uses to base their medical expert opinions on.
So how did you use the DSM-5 in this case?
I used the DSM-5 for both the definitions of schizophrenia and malingering, and after reviewing all the relevant medical and personal data, came to the conclusion that the defendant was in fact not a schizophrenic, but rather malingering.
Dr. LaGreca, you should be seeing Exhibit 17B on the screen, the DSM-5 definition for malingering.
Yes.
Could you read that top paragraph?
Sure. Malingering is the simulation of a disease characterized by the intentional production of falsely or grossly exaggerated physical or psychological symptoms, motivated by external incentives. Examples of such incentives include avoiding military duty, avoiding work, obtaining financial compensation, evading criminal prosecution, or obtaining drugs.
So which of those motivations applies in this case?
Evading criminal prosecution.
Right. Set that down. What other things did you review to reach a conclusion in this case?
I looked at his medical history, the defendant's medical history. I looked at Dr. Riley's report, and I also looked at both officers' investigations and reports.
Why didn't you interview the defendant, though?
I was not given the opportunity to do so.
And why didn't you interview anyone else in this case?
I thought with the information I had at hand, I was able to reach. I had a very high certainty of reaching a conclusion of my conclusions, and decided it was not necessary to do so anymore.
You mentioned you reviewed Dr. Riley's report. What symptoms of schizophrenia did Dr. Riley claim were present?
She claimed that the defendant had auditory or had hallucinations, delusion, paranoia, and delusions, and other symptoms, negative symptoms. But while these symptoms are seen in schizophrenia. There are a host of other reasons for why the patient might be producing these symptoms, and that are much more likely given the patient's medical history.
Was the defendant ever diagnosed with something that could cause these symptoms?
Yes, he was actually diagnosed with general anxiety disorder, and all of his symptoms can be explained by just this diagnosis.
Who was the one who diagnosed him with that?
He was diagnosed in 2010 by Dr. Riley, who is on the defense.
All right, I'd like to talk about the defendant's behavior during the killing of Nathan Ray. What did the defendant tell Dr. Riley he did in his bedroom during the killing of Nathan Ray?
Right before he right before or during the investigation, it was found out that before he killed his son, he was just lying, waiting in his room, thinking about his actions.
What did the defendant do on his bed?
He was sitting down, just thinking.
Objection, Your Honor. Speculation.
Response?
Your Honor, the defendant has actually testified that to Dr. Riley that he was sitting down on the bed trying to calm down. Trying to calm down is a form of thinking, I would argue.
Is this the defendant taking time to think? Is that within some of the materials that Dr. LaGreca has reviewed?
Yes, it is, Your Honor. It is within Dr. Riley's report.
I'm going to overrule your objection.
All right, Dr. LaGreca, how did the defendant sitting down on his bed affect your diagnosis?
It further supports the diagnosis of malingering.
Okay, let's turn to the defendant's behavior when he was stopped by police. Are you familiar with Officer Wentz's statement?
Yes, I am.
And when did the defendant begin showing signs of schizophrenia when he was stopped by Officer Wentz?
The defendant only started showing signs of schizophrenia once Officer Wentz had found incriminating pieces of evidence in the back of his car. Prior to the officer realizing this, according to his own report, he was not showing any signs of schizophrenia, which is again consistent with a diagnosis of malingering. He only started exhibiting these symptoms once he realized that he had been caught.
All right, let's turn to the defendant's medical history. What did the defendant's medical history show regarding schizophrenia?
He has never had a diagnosis of schizophrenia. He's only had a diagnosis of general anxiety disorder, which is a completely separate psychiatric illness.
And how did the lack of a previous schizophrenia diagnosis affect your conclusion?
Schizophrenia is a very chronic, debilitating disease that lasts years. It would have shown up by now in his medical history if he really had schizophrenia, given the nature of the schizophrenia that the defense is trying to argue.
And how did the lack of diagnosis or things like that affect your conclusion?
Again, because he's never been diagnosed and he's never had any symptoms of schizophrenia before, this all provides further support and evidence towards my diagnosis of malingering.
So let me ask you this then. How consistent are all of these facts with schizophrenia?
They're not consistent at all.
What diagnosis are all of these facts consistent with?
They're much more consistent with a diagnosis of malingering.
Nothing further for this witness at this time, Your Honor.
Mr. Mills, whenever you're ready.
That's Your Honor. Dr. LaGreca, as you said on direct, this isn't the first time you've testified as an expert witness.
That is correct.
It's your 8th time.
Yes.
And the 7th you've testified for the prosecution.
Yes.
And as you said, the prosecution hired you in this case to give your opinion about Timothy Ray's mental health the day he killed Nathan.
Yes, my medical expert opinion.
You charged them $500 an hour to review the materials.
As is customary in these types of proceedings.
Materials that took you 25 hours to review.
That was more than sufficient enough time.
Is that a yes?
Yes, that was enough time for me to review the documents.
So for a total of $12,500.
Well, I have other responsibilities, and this takes away time from that. So I wanted to make sure that I was financially compensated, and it is well within my right to do so.
To be clear, doctor, I'm just wanting to confirm you were paid a total
Yes,
of
I was
$12,500.
paid. I was paid as customary when doctors serve as medical expert.
And your testimony here today costs an additional $1,750.
Yes, again, showing up today takes time away from my students and my patients.
So for a grand total of just over $14,000.
Yep.
Doctor, one of the things you considered informing your opinion in this case was the DSM-5.
Yes.
And as you said on direct, the DSM-5 is the gold standard.
It is the document that we try to base all of our diagnoses off of. It is the gold standard in terms of the definitions. We use it thoroughly to when applying these definitions. We use our own clinical judgment in addition and rely on it for the definitions and the constructs of the diseases.
Now, doctor, someone may be diagnosed with schizophrenia if they experience at least 2 of the listed symptoms for at least 1 month.
Is there a question there?
Someone may be diagnosed with schizophrenia if they experience at least 2 of the listed symptoms for at least 1 month, correct?
No, they also have to rule out other medical and psychiatric illnesses, as well as any drug use. There's also 2 other things that they have to rule out, which is also present in the DSM-5.
So the answer to my question is yes, they may be diagnosed in addition to all that if they experience at least 2 of those listed symptoms.
I'm sorry, could you clarify your question?
So, doctor, just clear, if somebody experiences 2 of the listed symptoms in addition to everything you said, someone may be diagnosed with schizophrenia.
Yes, as long as you rule out other possible causes and you do a full workup and they have those symptoms, that would be what is required to diagnose someone with schizophrenia.
Now, delusions are one of those symptoms, correct?
They are one of the 5, yes.
A delusion is a strongly held belief that's not rooted in reality.
That is the definition of delusions, yes.
Doctor, you also reviewed a transcript of Dr. Samantha Di Giuseppe's testimony for your report.
Yes, I did.
Objection.
Doctor,
Basis?
At this time, we would like to re-raise the objection we made in our pretrial motion. We believe the defense is going to elicit testimony regarding Dr. Di Giuseppe, and that this would violate both the best evidence rule and would solicit improper opinion testimony. The defense is attempting to use this non-expert testimony through the mouth of an expert, and therefore we argue it should not be permitted.
Thank you for that. I'm going to stand on my prior ruling of the motion in limine, which was denied. So Mr. Mills, you can continue. Your objection is overruled.
so to be clear, Dr. Di Giuseppe was Mr. Ray's primary care doctor.
Yes, he was his family practice doctor.
And you reviewed her transcript for your report.
I reviewed it, yes.
And in that transcript, she talks about her visits with Mr. Ray.
Yes, I believe they met 3 times over the course of 7 years.
Her last visit was in 2016 or 2017.
That is correct.
And she said that she was worried about Mr. Ray when she saw him.
Yes.
In fact, she was so concerned that she asked Mr. Ray if he was thinking about hurting himself.
Yes, she was worried. As a primary care physician, one of the things you're worried about is suicide and suicidal ideation, which is seen in psychiatric illnesses, but also just in not necessarily schizophrenia, but also in depression, general anxiety disorder, mood disorders like bipolar disorder. It's not at all specific to schizophrenia.
Well, in response to that question that she asked, Mr. Ray responded by calling her, and I quote, a goddamn bitch.
Those were his words, yes.
and accused her of plotting with his ex-wife against him.
Is there a question?
He accused
Oh, yes,
Dr.
yes.
DiGiuseppe
That's what it was in the report.
and of listening to his phone calls, correct?
That was also in the report.
Doctor, you're not aware of any evidence that Dr. DiGiuseppe ever spoke to Mrs. Ray,
I have no evidence of that.
or that the doctor was secretly listening to Mr. Ray's phone calls.
I have no evidence of that.
Now, on the night he was arrested, Mr. Ray told the police that the CIA was looking for him.
Objection, Your Honor. Hearsay.
Response, Mr. Mills?
Your Honor, we're not using Mr. Ray's statements about the CIA to try and prove them. We're using them as circumstantial evidence of his schizophrenia at the time.
So am I correct in saying you're not offering those statements for their truth?
That's correct, Your Honor.
Okay. Overruled.
Doctor, on the night he was arrested, Mr. Ray told the police the CIA was looking for him.
Yes, he was concerned about the CIA.
Looking for him for terrorism.
I believe that is true.
Mr. Ray also accused the police officers with him that night of being CIA agents.
Yes, he did.
Doctor, you didn't find any evidence that the CIA was actually looking for him, correct?
I'm a medical expert. I have no idea what the CIA is doing or looking for.
But to be clear, you didn't find any evidence in the materials you were provided with.
I have no information about the CIA and their
or that Timothy Ray was some terrorist.
Yes, I have no information about that.
Or that Detective Booth or Officer Wentz are really CIA agents.
Yes.
Now, doctor, hallucinations are another symptom of schizophrenia, correct?
Hallucinations are another, among other diseases, yes.
You're aware that Mr. Ray told Dr. Riley that he had been hearing voices since he was 10 years old.
Yes, I am.
And that while Mr. Ray was in the Army, his commanding officer reported that Mr. Ray was seeing things.
Yes, that was in 2010.
And that on the night of his arrest, Officer Wentz reported that Mr. Ray appeared to be talking to people that weren't there.
Yes.
Doctor, you also reviewed Mr. Ray's medical records from jail, correct?
That is correct.
You're aware that in 2019, he saw a doctor in the facility.
Objection, Your Honor. Relevance.
Response?
Your Honor, Dr. LaGreca reviewed all of the materials in this case, and per the jury instructions, the expert and the jury are allowed to use any evidence before, during, or after the matter at hand to be able to determine, the ultimate issue in this case. What happened in this case, Mr. Ray's state of mind.
So, Mr. Mills, I believe that the objection was to relevance as to Mr. Ray seeing a physician while he was in prison. Do you have a response to the relevance of Mr. Ray seeing a prison doctor after he was arrested?
Yes, as an offer of proof, if allowed to testify, the doctor will say that while Mr. Ray was in prison, he saw the doctor, and the doctor prescribed Mr. Ray with a medication called Seroquel, which is an antipsychotic used to treat schizophrenia. So that's, that would make it more likely that Mr. Ray was suffering from schizophrenia.
Your Honor, may I respond?
I'll give you the last word.
Thank you. This is not relevant because the events described here are occurring well after the killing of Nathan Ray. If defense wishes to solicit testimony regarding what happened then or the defendant's mental condition then, we welcome it. But as this is well after the killing, it is not relevant.
Since Mr. Ray's mental health is at issue, I will allow this line of questioning, so I'm going to overrule your.
Doctor, you're aware that in 2019, Mr. Ray saw a doctor while in the facility.
Yes, I am aware.
And that doctor prescribed Mr. Ray with a medication called Seroquel, correct?
That is correct. But I'd like to, could I respond, or is there another question you have?
I have another question. Seroquel is an antipsychotic drug, correct?
Your Honor, I'm sorry, but if the witness may be allowed to finish his answer.
In all fairness, Mr. Hulsberg, Mr. Mills had started another question and the witness had interrupted. You may clarify any points you want to clarify and redirect.
Thank you, Your Honor.
Doctor, to be clear, Seroquel is an antipsychotic drug, correct?
Seroquel can be used for treating schizophrenia, but it also can be used for other psychiatric illnesses, including bipolar, and sometimes off-label as an antidepressant. Additionally, the doctor in question here, I'm not sure of his qualifications. I don't know if he's a general physician or a psychiatrist, nor did he make any formal diagnosis of schizophrenia at the time that he gave the patient Seroquel. So while Seroquel, yes, is typically used as an antipsychotic, he did not make a diagnosis of schizophrenia, nor do I know his qualifications as to what made him go down the path of giving Seroquel in this matter.
But to be clear, doctor, Seroquel can be used to treat schizophrenia?
It is one of the reasons why you would use Seroquel, yes.
And as far as you know, Mr. Ray hasn't been diagnosed with any other disorder such as bipolar that Seroquel would be used to treat.
Seroquel, yes, and he was not diagnosed with schizophrenia or bipolar at the time of him being given Seroquel.
Well, to be clear, Dr. Riley did in fact diagnose Mr. Ray with schizophrenia.
When did he do that?
Doctor, you had a chance to review the materials of this case, correct?
Yes. I'd like to review it right now too.
Well, doctor, to be clear, you're aware that Dr. Riley diagnosed
yes, I am
during
aware.
the medical.
Yes.
No further questions at this time, Your Honor.
Mr. Hulsberg, any redirect?
Yes, Your Honor. Dr. LaGreca, how did you arrive at your fee?
I'm a medical expert, and these are just customary fees for what I use for any time I serve as a medical expert.
And how did Dr. DiGiuseppe's, statements and testimony impact your diagnosis?
While I reviewed it, I considered her statements, and given her limited expertise in dealing with mental illnesses, while I appreciate her concern for her patients, I believe her concern about mental health was limited to his diagnosis of general anxiety disorder and not schizophrenia.
Your Honor, we have nothing further with this witness, and at this point, the government rests.
Okay, Dr. LaGreca is excused. Are there any motions?
Yes, Your Honor. At this time, the defense would like to make a motion outside the presence of the jury.
Yep, everyone is presumably heard outside the presence of the jury. You can go ahead with your motion.
Just to preserve the record on appeal, we move pursuant to Federal Rule of Criminal Procedure 29. The defense moves for a judgment of acquittal.
Your motion will be respectfully denied. Okay, why don't we get a time check here?
One moment while we confer, Your Honor.
Yeah, sure thing.
Your Honor, we have 27:20 left for the prosecution and 31:45 left for the defense.
Okay, and you are for the defense?
For the defense.
And prosecution timekeeper, do you have something at least close to that?
Yes, Your Honor, we conferred and we agreed on those numbers.
Okay, great. Are the parties ready to proceed to defense's case in chief?
May we have a brief 5-minute recess?
Yes. It is 4:36 Central Time. We'll come back at 4:41.
Thank you, Your Honor.
Hey! Hey, Dad. Hello? Hello.
Judge, I believe you are not mute.
You're not muted. Oh.
Oh, that's embarrassing. I have told my father that I'm in the middle of judging a mock trial competition. Okay, is everyone ready?
Yes, Your Honor.
Yes, Your Honor.
All right, defense, you can call your first witness.
The defense calls Officer Peyton Wentz to the stand.
Officer Wentz, you are constructively sworn in. Mr. Mills, you can start your questioning whenever you're ready.
Yes, Your Honor. Hello, please introduce yourself to the jury and tell us what you do for a living.
Hello, my name is Peyton Wentz, and I am a police officer with Skelton PD.
And how long have you been an officer for Skelton PD?
About 4 years now.
And what's your current assignment?
I work patrol, so I spend most of my shift patrolling the city and responding to radio calls.
Were you working the night of October 19th, 2018?
Yes, my partner and I were working a DUI checkpoint in the city.
And at some point that night, did you meet Timothy Ray?
Yes, he was one of the drivers that came through the checkpoint that night. I remember he looked pretty rough.
What do you mean?
Mr. Ray just looked bad. His hair was all messed up. His eyes were glassy. His shirt was rumpled and stained, and he smelled terrible. I could actually smell him from outside of the car.
Now, what happened when Mr. Ray drove up to the checkpoint?
I asked for his license and registration, but at first he wouldn't give them to me. He started arguing, saying he left his wallet at home, but I could see that it was sitting right there next to him, so I pointed that out to him.
And what happened when you pointed out his wallet?
He then gave me his license and registration.
What did you do after he gave you his license and registration?
I started to walk back to my patrol car to check the information, and as I walked by, I took a quick look around Mr. Ray's car with a flashlight.
Why'd you look around his car?
At that point, I was suspicious. He had been acting odd.
Odd? You say odd. What, did you think he was drunk?
No, it wasn't that. He wasn't slurring his words or speaking slowly, and I didn't smell any alcohol. It was just the way he looked and his defiance.
So what did you see when you looked into his car?
Well, his car was a mess. There was trash everywhere. And then I could see trash bags, a shovel, and a couple containers of bleach on the back seat of his car.
What did you do when you saw those items in Mr. Ray's car?
I asked my partner to run a computer check on Mr. Ray to make sure there were no warrants and that his license was still valid. And then I returned to Mr. Ray because I wanted to keep an eye on him.
What happened when you got back to Mr. Ray?
Well, out of the blue, he just started yelling at me and asking crazy questions.
What do you mean?
He yelled at me, "Are you with the CIA?" And that he knew the CIA had been watching him because they thought he was a terrorist. He also said he could hear CIA sirens coming to get him.
Could you hear any sirens?
No, there were no sirens.
So what'd you do?
Well, I spoke calmly to him. I told him, I was not with the CIA. I tried to explain why we had pulled him over. And then at that point, I did ask him to step out of his car.
Did he follow your direction?
Eventually, he did. He kept asking for my CIA credentials, but he did get out of the car eventually.
What was his demeanor after he got out of his car?
He started moving really slowly, almost like a robot. He had this blank stare on his face and he wasn't making eye contact with me anymore. Then he just kept muttering, "I'm a good father. I didn't mean it," over and over again.
What happened next?
Then he started to do jumping jacks.
Jumping jacks?
Yes, it was really weird. He said something about trying to get his son in shape and to admit that the son had broken something. And then he all of a sudden looked at me like he was noticing me for the first time.
So what did you do?
Well, I ordered him to stop moving around, but he continued doing jumping jacks. So I then had to draw my gun and order him to stop moving.
Did he stop?
Well, he stopped jumping, but then he started thrashing his head around uncontrollably, and he put his hands over his ears like he was trying to cover out sound, shut out sound almost. And that's when I decided I needed to handcuff him so I could figure out what was going on.
After you handcuffed Mr. Ray, what'd you do?
Well, my partner told me that Mr. Ray's plates had come back flagged on a missing persons report about a little boy. So I told my partner to watch Mr. Ray while I radioed dispatch about the stop. Then Detective Booth showed up about 20 minutes later.
What did Detective Booth do after she arrived?
She had me and my partner shut down the checkpoint and escort Mr. Ray to the police station in our patrol car.
As you took Mr. Ray back to the station, how was he acting on the drive?
He was crying and talking to himself.
Officer Wentz, did you ever tell Detective Booth about Mr. Ray's behavior when you pulled him over?
Yes, a couple days after we arrested Mr. Ray, Detective Booth interviewed me to figure out what had happened before she had arrived. It was at that point that I told her how bizarrely Mr. Ray was acting when I pulled him over.
Thank you, Officer Wentz. No further questions at this time, Your Honor.
Mr. Hillsberg, do you have a cross-examination?
Yes, Your Honor.
All right, go ahead.
Officer Wentz, you stopped the defendant as part of a DUI checkpoint.
Yes.
You went up to the driver's window.
Yes, I did.
You asked for the defendant's license and registration.
That's correct.
He asks why you needed it.
Yes, he did.
So you explain to him it's a routine traffic stop.
Yes, it was a random stop at that point.
He tells you he left his license at home.
Yes.
He also tells you he doesn't keep his registration in the car.
That's right.
But you see the defendant's wallet in between the seats.
Yes, I could see it right there in plain view, so I pointed that out to him.
And after you looked at him a little, he groaned and gave you his registration too.
Yes, he did.
He wasn't asking if you're CIA yet.
No, that was after.
He wasn't speaking in a monotone voice.
No.
He isn't shouting about his dead son.
Like I said, not at that point.
He isn't waving his arms around.
No.
Okay. So after you got the license, you walk back to your squad car.
Yes, that's correct.
But before you did, you shine your flashlight in the back seat.
Yes. He was acting odd at that point, so I decided to just take a quick look around.
We'll talk about how odd he gets in just a second. You shined your flashlight in the back seat while the defendant was still in the car.
Yes.
You see a shovel.
Yes, and trash bags and a couple of bottles of bleach as well.
Okay, so let's compare the defendant's behavior before you saw those items in the backseat to after. Then he gets odd.
Yeah, but right away when I pulled him over, I could tell something was off.
Right, but now he's asking you if you're in the CIA.
Yes, that's correct.
And after you ask him to step out of the car, that's when he acts really monotone.
Yes, he was moving really slowly and wasn't making eye contact with me.
And then he starts doing jumping jacks.
Yes.
He begins shouting about his dead son, Nathan.
Yes. Yes.
He puts his hands over his ears like you demonstrated while his head swings around.
Yes, he was just thrashing around uncontrollably.
And you told Detective Booth that all of these things only happened after you looked in the back seat.
I told Detective Booth exactly what happened and that from the moment I saw this man, I knew there was something wrong. And then I took him through the events, just like you said.
So we agree that you told Detective Booth that all of these things happened after you looked in the back seat.
Yes, I gave him a timeline. Gave her a timeline, pardon me.
Nothing further at this time, Your Honor.
Mr. Mills, any redirect?
No redirect, Your Honor. May this witness be excused?
Yes, she may. Defense, do you have any more witnesses?
Yes, Your Honor. The defense calls Dr. Shane Riley.
All right, Dr. Riley, you are constructively sworn in, and Ms. Rivera, whenever you're ready.
Good evening. Please introduce yourself to the jury and tell us what you do for a living.
My name is Dr. Shane Riley, and I am a forensic psychiatrist with my own private practice here in West Carolina.
What's forensic psychiatry?
It's the area of psychiatry that deals with mental illnesses and the justice system.
How long have you worked in the field of forensic psychiatry?
Over 20 years now.
Where did you go to school?
I received my bachelor's degree from the University of Notre Dame. I then received my medical degree from USU, which stands for Uniformed Services University School of Medicine, and I graduated 4th in my class.
What did you do after you received your medical degree?
I completed both my residency and forensic psychiatry fellowship at Walter Reed National Military Medical Center.
You just mentioned USU and Walter Reed. Are you in the military?
Yes, I'm a major in the U.S. Army.
What did you do after you completed your forensic psychiatry fellowship?
I taught as an associate professor of psychiatry at USU, and I was also then deployed to Iraq, where I was the primary psychiatrist who oversaw 20,000 soldiers.
What did you do after you returned from Iraq?
I worked as an associate professor of psychiatry for the residency program at Walter Reed, and I also managed the psychiatric inpatient unit where I treated hundreds of patients with a variety of mental disorders, including schizophrenia. Eventually, I was promoted to deputy director of behavioral health.
Are you board certified?
Yes, I'm board certified by the American Board of Psychiatry and Neurology.
Have you ever been published in the field of forensic psychiatry?
Yes. I've written 15 peer-reviewed articles in the field of forensic psychiatry, and 2 of them were specific to schizophrenia.
Have you ever testified as an expert before?
Yes, 25 times total, and 18 times were in a criminal case.
Do you usually testify on behalf of the defendant?
Most of the time I testify for the defense, but I have testified once for the prosecution.
Your Honor, at this time, we tender Dr. Riley as an expert in forensic psychiatry.
Any objection?
Your Honor, voir dire.
Granted.
Your Honor, may we have an offer of proof?
Go ahead.
Yes, Your Honor. This expert, or excuse me, the defense has tendered this expert in forensic psychiatry. Your Honor, we believe that during voir dire, this expert is going to testify that she does not have a board certification in forensic psychiatry. However, she does have a board certification in general psychiatry.
You know what, counsel, why don't you save those points for cross-examination?
Yes, Your Honor.
Dr. Riley, turning your attention to today's case, how did you get involved?
I was retained by your office to provide an opinion regarding whether and to what extent Mr. Ray suffered from any mental disorder at the time of Nathan's death.
How much do you charge for your time as an expert?
I usually charge $450 an hour to review materials and $1,500 per day for my trial testimony, but I reduced my rate to $350 per hour to review the materials in this case.
Why did you lower your rate to review the case?
I treated
Relevant.
Response, Ms. Rivera?
Your Honor, this goes to Dr. Riley's credibility. We have a good faith belief that the prosecution will try to elicit this testimony about why she lowered her rate to review the case. And so we're allowing Dr. Riley to testify to that.
Your Honor, if I may.
Go ahead.
We have no intent to elicit this testimony. Additionally, we believe that this is improper bolstering.
I tend to agree with Ms. Earhart. So the objection is sustained.
Dr. Riley, were you able to form any opinions in this case about whether Mr. Ray suffered from a mental illness on the day of Nathan's death?
Yes, I was.
What's the basis for your opinion?
My experience treating Mr. Ray, my review of his medical records, and my review of all materials on the exhibit list. I also conducted a clinical interview with Mr. Ray and interviewed his wife, his father, and his former boss.
Do you hold your opinion to a reasonable degree of medical certainty?
Yes, I do.
What is your opinion?
It's my opinion that Mr. Ray was suffering from severe schizophrenia at the time of Nathan Ray's death.
Dr. Riley, what is schizophrenia?
It's a mental disorder that causes people to suffer from symptoms like not being able to tell what is real and what is not. It can cause delusions and hallucinations, and it can also cause disturbances in behavior and thought.
Does everyone suffer from schizophrenia in the same way?
No, schizophrenia manifests on a spectrum. Some people can manage their symptoms with treatment, while others can experience symptoms so severe that it impairs their ability to understand the nature of their actions.
How does a doctor determine whether someone suffers from schizophrenia?
We compare the symptoms the patient has with the criteria in the Diagnostic and Statistical Manual of Mental Disorders, 5th edition, or DSM-5.
Your Honor, I have a document which has been pre-admitted into evidence as Exhibit 17A. This item can be found on page 93 of the record. Dr. Riley, do you have a copy of Exhibit 17A?
Yes.
Do you recognize it?
Yes.
What is it?
It's a page from the DSM-5 that shows the definition and the criteria for schizophrenia.
Does Exhibit 17A accurately state the DSM-5 definition for schizophrenia as you relied on it in coming to your opinion?
Yes, it does.
Permission to publish Exhibit 17A?
Granted.
Mr. Khan, can you call out the portion of the document under diagnosis? Dr. Riley, how many symptoms listed here in the DSM-5 does a patient have to suffer from to be diagnosed with schizophrenia?
At least 2 of the 5 criteria for at least a month.
Based on your evaluation, how many symptoms does Mr. Ray suffer from?
He suffers from 3 of the 5.
Which 3 symptoms?
Hallucinations, delusions, and negative symptoms.
What did you do to verify that Mr. Ray actually suffered the symptoms he reported to you?
I observed him firsthand during a clinical interview, and I reviewed his records. I also interviewed the people closest to him, including his wife, his father, and his former work supervisor.
Now, I'd like to take those 3 symptoms you just mentioned one at a time. What evidence was there that Mr. Ray suffered from hallucinations?
Mr. Ray reported hearing voices, which indicates auditory hallucinations. He also reported seeing triangles on the wall, which change shapes and colors, which constitute visual hallucinations.
How long did Mr. Ray say he's been suffering from hallucinations?
Mr. Ray reported that he had been having or hearing voices since the age of 10. He recently reported hearing male voices telling him to hurt other people. He said he began having the visual hallucinations at the age of 31, continuing through the time of Nathan's death.
Now, you mentioned earlier that Mr. Ray was a patient of yours in 2010. Was there any evidence of hallucinations at that time?
Yes. When I evaluated Mr. Ray in 2010, he had just been discharged from the Army. Mr. Ray's commanding officer reported that Mr. Ray was seeing things and that he was suicidal. We had to hospitalize him for 3 days.
What was your diagnosis back in 2010?
Generalized anxiety disorder.
Why didn't you diagnose Mr. Ray with schizophrenia at that time?
At the time, Mr. Ray was not exhibiting all of the symptoms of schizophrenia, and he denied having hallucinations.
Now, the second symptom you mentioned Mr. Ray suffers from are delusions. What are delusions?
Delusions are false beliefs that a person firmly holds, despite the fact that they are not based on reality.
What evidence was there that Mr. Ray suffers from delusions?
During my 2019 interview with Mr. Ray, he told me that in 2015, he was convinced that his wife and son, who was 3 years old at the time, were going to stab him. Mr. Ray also accused me of having a camera in my microwave recording him and of being part of a government conspiracy to get him.
Was there any other evidence of delusions?
Yes. Mr. Ray also accused his primary doctor of eavesdropping on his phone conversations and talking to his wife behind his back.
Now, the third symptom you mentioned Mr. Ray suffers from are negative symptoms. What are negative symptoms?
Negative symptoms are symptoms that can impair a person's functioning. Examples include an impaired ability to manage emotions, such as angry outbursts or episodes of crying, withdrawing from relationships, and poor hygiene.
Was there any evidence that Mr. Ray suffers from negative symptoms?
Yes. I witnessed it myself when Mr. Ray had a meltdown when I interviewed him in 2019. I also reviewed testimony from Mr. Ray's family doctor, Dr. Samantha DiGiuseppe, and that supported my diagnosis.
What did you learn from your review of Dr. DiGiuseppe's testimony?
I learned that she saw Mr. Ray 3 times between 2010 and 2017. During these visits, she reported that Mr. Ray broke down crying hysterically in her office and that he was disheveled and looked like he hadn't showered in weeks. When she asked Mr. Ray if he was okay, he told her he'd never been okay.
You said earlier that you interviewed the people closest to Mr. Ray. What did you learn from those interviews about Mr. Ray's diagnosis?
I spoke with Mr. Ray's former supervisor and learned that Mr. Ray tried to fight a coworker simply because they didn't follow his directions. I also spoke with Mr. Ray's wife, who reported that he would lock himself in the bathroom and cry for hours. It was so bad that Mrs. Ray begged Mr. Ray to see a psychiatrist.
Did you learn anything else from your interviews that supports your diagnosis?
Yes. Mr. Ray's father told me that Timothy Ray's mother was institutionalized for severe mental illness and that she abused Mr. Ray horribly.
Objection, Your Honor, and move to strike.
Basis?
Yes, Your Honor. We believe that the testimony that was just elicited lacks foundation. There is no evidence to support that Timothy Ray's mother was institutionalized for a mental illness back when the defendant's father says he was.
Ms. Rivera?
Yes, Your Honor. Both experts in this case agree that genetics and family history play a role in a person's mental health development. Now, this was the basis of Dr. Riley's opinion, as well as the basis of Dr. LaGreca's opinion. And the jury should be allowed to hear this evidence to weigh the credibility of that opinion.
So I believe that Ms. Earhart's concern is that whether or not the mother was institutionalized specifically for a mental illness and whether that's part of the materials that Dr. Riley reviewed. Is that right, Ms. Earhart?
Yes, Your Honor, that's correct.
Do you have a response to that, Ms. Rivera? Is there something in the materials that does indicate that Mr. Ray's mother was institutionalized for mental health?
Yes, Your Honor. Abe Ray, the husband of Mrs. Ray, told Dr. Riley that during an interview when Dr. Riley was forming her opinion for this case.
Your Honor, if I may.
You may.
That interview with the defendant's father would be speculating. There's no medical documentation. There's no evidence to support that the defendant's mother was institutionalized, in fact, for any type of mental illness.
Are you changing your objection to speculation now?
It would be to the lack of foundation. And then if the defense is saying that it would be based off of the defendant's father's testimony, that would be speculation as well.
Okay, I'm going to overrule the objection.
Dr. Riley, what did you learn from your interview with Mr. Ray that supports your diagnosis?
Mr. Ray's father told me that Timothy Ray's mother was institutionalized for severe mental illness and that she abused Mr. Ray horribly. And that's important because if someone has a family member who suffers from a mental illness like schizophrenia, that increases the likelihood that a child or sibling will also suffer from it.
You said Mr. Ray's mother abused him. What do you mean?
Abe Ray reported that Mr. Ray's mother was neglectful and abusive toward him. She often refused to feed Mr. Ray and forced him to take cold baths. She then abandoned Mr. Ray at a very young age.
Dr. Riley, what evidence was there that Mr. Ray suffered from schizophrenia around the time of Nathan's death?
Mr. Ray exhibited signs of both visual and auditory hallucinations in front of both of the officers involved in his arrest. Mr. Ray told Detective Booth that he heard voices telling him to do what he did to Nathan. Additionally, Officer Wentz reported that at the traffic stop, Mr. Ray said that he could hear sirens of the CIA coming to get him.
Were those the only symptoms he showed that night?
No. Mr. Ray showed evidence of delusions. He accused both Officer Wentz and Detective Booth of being a part of the CIA and told Officer Wentz that the CIA had been watching him because they thought he was a terrorist. Mr. Ray's appearance and overwhelming body odor are also evidence of negative symptoms.
Dr. Riley, were you in the courtroom when Dr. LaGreca testified?
Yes, I was.
Did you hear Dr. LaGreca's opinion that Mr. Ray was faking symptoms?
Yes, I did.
Do you agree with that opinion?
Absolutely not.
Why did you conclude Mr. Ray wasn't faking symptoms?
Mr. A has been tormented by symptoms of schizophrenia since he was just 10 years old, well before the need for a legal defense.
Based on your review of the record, are you the only doctor that has diagnosed Mr. Ray with schizophrenia?
While I'm the only one who's given Mr. A the formal diagnosis, he has been treated for his symptoms consistent with schizophrenia.
What do you mean?
Last year, while Mr. A was in the Skelton County Department of Corrections, he made a mental health appointment. While the physician who saw Mr. A never formally diagnosed him, Mr. A was prescribed Seroquel.
Why is it significant that Mr. Ray was prescribed with Seroquel?
Hold on one
Seroquel?
second. I think Ms. Earhart is trying to object. I don't know if your volume.
Apologies, Your Honor. I'm not sure if there was maybe a Zoom delay or if that was just a me delay. But we would like to object and move to strike on the grounds of relevance. Timothy Ray's diagnoses after Nathan Ray's killing are irrelevant in this trial.
Ms. Rivera, do you have a response?
Yes, Your Honor. Prior to this trial, both the prosecution and the defense stipulated to the jury instructions. And part of the jury instructions, the jury is allowed to consider evidence of Mr. Ray's mental condition before or after the offense charged.
I tend to agree with Ms. Rivera. Ms. Earhart, your objection is noted. However, it is overruled.
Dr. Riley, what do you mean that you were not the only doctor who diagnosed Mr. Ray with schizophrenia?
While Mr. A was in the Skelton County Department of Corrections, he was actually prescribed Seroquel.
Why is it significant that Mr. Ray was prescribed with Seroquel?
Seroquel is an antipsychotic. It's used to treat serious mental disorders such as schizophrenia, bipolar, and sudden episodes of mania or depression associated with bipolar disorder.
Your Honor, I have no further questions at this time.
Ms. Earhart, cross-examination.
Thank you, Your Honor. Good evening, Dr. Riley.
Good evening.
Now, just to be clear, you are board certified in general psychiatry, is that correct?
Yes, that's correct.
You are not board certified in forensic psychiatry.
I actually completed a one-year fellowship at Walter Reed National Military Medical Center in forensic psychiatry in 2002.
You would agree, Dr. Riley, that in order to get a board certification, you have to take an examination.
That's correct.
And you did not take the forensic psychiatry examination to get that board certification.
That's simply not listed on my CV.
All right, Dr. Riley. Now, just to confirm, you're no longer active duty in the Army, right?
That's correct.
You've opened up your own private practice since you've left the Army.
Yes, that's correct.
And overall, you've worked on 25 cases.
Yes, that's correct.
In 22 of those times, you've worked for the defense.
In criminal cases, there were, I believe I did 18 of them, and 17 were for the defense, and one was for the prosecution.
Yes, but that also included your court-martial experience, which are also criminal trials. Is that correct, Dr. Riley?
Yes.
So 22 of the 25 times you have testified for the defense.
That's correct.
Now, you provided an opinion for the defendant in this case.
Yes, that's correct.
The defense has hired you to be here.
Yes, but I just want to clarify that they hired me for the time and the work that I put into providing a psychiatric evaluation, not the opinion.
Understood. Let's talk about the evaluation that you conducted. So first, you were doing that evaluation for schizophrenia, is that right?
I was doing the evaluation to evaluate for any possible mental illness.
You would agree that schizophrenia is a progressive disease?
It's a chronic disease, and it can progress if it's untreated, as with the case with Timothy Ray.
Right. So these symptoms would persist over time.
Yes.
So I want to talk about exactly all of the things you looked at over time to get you to your point here in this trial today.
Sure.
Now, you reviewed all of the materials in this case.
That's true. Yes.
You reviewed hundreds of pages at this point.
Yes.
Hundreds of pages that included testimony from a Dr. DiGiuseppe.
Yes, that's correct.
And when you reviewed this deposition, you understood that Dr. DiGiuseppe wasn't a psychiatrist.
Yes, but she is a family medicine doctor and they're trained in all areas, including psychiatry. And that's actually something that she talks about during her deposition as well.
That's correct, but Dr. De Giuseppe, during her testimony, said that she was not qualified to talk about mental illnesses. Is that right?
I wouldn't say that she's unqualified to talk about mental illnesses. It's more so that if something is really severe, then she refers out to a psychiatrist, as with the case with family medicine doctors.
It's your testimony today, Dr. Riley, that Dr. De Giuseppe did not say, I am not equipped to treat mental illnesses.
I believe that she said that there are some mental illnesses that she's not equipped to treat, and she will refer out in that case.
Correct, but she didn't in this case.
Can you repeat that?
She did not provide a referral for the defendant in this case.
She actually did. In 2016 to 2017, she actually did refer the defendant to her friend, Dr. Erin Hohall.
Well, to be clear, Dr. Riley, she called a friend. She didn't refer the defendant.
Her friend was a physician herself. So I think that in the medical field, we do make friends with other physicians, and it's okay to refer to friends.
All right, let's talk about what we did learn from Dr. De Giuseppe. So Dr. De Giuseppe said that she never had the defendant report hallucinations.
No.
And she also said that he'd never reported hearing voices.
No.
Let's talk about some of the other information that you gathered in this case. You conducted interviews, is that right?
Yes.
You interviewed the defendant's father. You mentioned that on direct.
Yes.
But the defendant's father never mentioned hallucinations.
No.
Never mentioned hearing voices.
No.
You also interviewed the defendant's boss. You talked to her, correct?
Yes, that's correct.
And she also never mentioned that the defendant had hallucinations.
No, and these are really all lay people, so I wouldn't really expect them to be able to recognize what hallucinations are.
Sure, but they're close to the defendant, right?
Absolutely.
And the boss, so just to be clear, the boss, she never heard anything about hallucinations?
No, he did have an incident at work, though, where he tried to fight one of his coworkers, and that does coincide with the time when he had the onset of these auditory hallucinations in early 2018.
Dr. Riley, my question was, did the boss ever tell you about any hallucinations?
No, and again, I wouldn't expect her to recognize hallucinations.
The boss never mentioned anything about hearing voices?
No.
And you also did an interview of the defendant's wife, correct?
That's correct.
And the defendant's wife, she never mentioned anything about hallucinations.
She never mentioned hallucinations, but she mentioned a number of things that are concerning for negative symptoms.
She never mentioned hearing voices.
She never mentioned hearing voices, no.
Now let's talk about what else we learned from the defendant's estranged wife, Dr. Riley. She was having an affair, is that right?
Yes.
She'd been having an affair for months.
Yes.
She'd been having an affair with the defendant's next door neighbor.
Yes, that's correct.
And she was going to leave the defendant.
Yes, this happened later on, yes.
And the defendant knew that she was going to leave.
Yes.
He was upset about this.
Yes.
He said he couldn't go on living without his Jessie.
Yes, so suicidal ideation is also one thing that's concerning for mental illness.
Now, the defendant's wife told him that she was going to leave him just days before he killed Nathan.
Yes.
All right, Dr. Riley, I want to change gears a little bit. This wasn't the first time you'd evaluated the defendant, correct?
That's correct.
You evaluated the defendant back in 2010.
That's correct.
When he was a soldier.
Yes.
When you were a soldier.
Yes.
You were a psychiatrist for the Army.
Yes.
And your job was to make sure that soldiers were fit for duty.
Yes.
You took your job seriously, right?
Of course.
It was a matter of national security.
Of course.
And so when you took this seriously, you ended up doing an evaluation of the defendant for 3 days.
Yes.
Over 3 days, you had the opportunity to observe him.
Yes.
You conducted an interview with him.
Yes.
And Dr. Riley, at the end of those 3 days, you diagnosed the defendant with a general anxiety disorder.
Yes. At the time, he was denying hallucinations, which unfortunately is not uncommon for patients who have mental illnesses.
Well, Dr. Riley, help me out here. On direct, you said that he'd been exhibiting symptoms of schizophrenia since he was 10 years old.
Yes, he's been hearing voices since he was 10 years old.
And that you said he was showing signs of schizophrenia in 2010.
Yes, Officer Cruz actually reported that he had been seeing things and sleepwalking for about a month.
Dr. Riley, if he was exhibiting symptoms of schizophrenia since he was 10 years old and since 2010, why didn't you diagnose him with schizophrenia?
Because at the time, he denied the hallucinations and he was denying all the symptoms, or he didn't have enough symptoms, I should say, to fit the criteria for a diagnosis of schizophrenia. However, over the years, so between 2010 to 2017, multiple accounts from Officer Cruz, Dr. DiGiuseppe, and Jessica Ray helped me come to the conclusion that he does, in fact, have schizophrenia.
Well, the defendant's own words helped you come to that conclusion too, correct?
Yes, but that's not the only thing we look at. We also look at whether or not other people see and recognize that he has symptoms as well.
Well, he's the only one that's reported to you that he could hear things.
Yes.
He's the only one that's reported visual hallucinations.
Yes.
So you only have the defendant's word to rely on those things.
Yes, that's always the case whenever we're describing or we are diagnosing someone with schizophrenia, because by definition, hallucinations are really visual or auditory things that only the patient can see or hear. And they think that everyone else can, but really no one else can.
All right, Dr. Riley. Well, the last thing that I'd like to talk to you about is malingering. You're familiar with that term?
Yes.
It's a part of the diagnostic manual that you talked about earlier.
That's correct.
And you would agree that someone might malinger for an incentive.
Yes.
An incentive like avoiding a criminal prosecution.
Yes, that can be one reason.
And you were actually at one point concerned that the defendant might be malingering. Is that right?
I always consider malingering. It's just something that you do as a psychiatrist. So yes, I definitely considered that.
Well, Dr. Riley, in your report, you were concerned about inconsistencies with the defendant's story.
Yes.
And you can't say today with certainty that the defendant isn't malingering.
I can say with reasonable degree of medical certainty that the evidence for schizophrenia far outweighs any concern for malingering.
But Dr. Riley, you would agree that there is a possibility the defendant is malingering.
Yes, of course. I considered that and did not come to that conclusion.
Thank you, Dr. Riley. I have no further questions for you.
Ms. Rivera, any redirect?
No redirect, Your Honor. May this witness be excused?
Yes, she may.
Your Honor, with that, the defense rests.
Okay, are there any motions?
We re-raise our motion on the same grounds.
It is again respectfully denied. Can we get a time check? And then I'm guessing that our closers will want a brief recess.
Yes, Your
a brief moment to confer on the time.
Sure thing.
Your Honor, we have conferred and we have 13 minutes and 56 seconds for prosecution remaining and 12 minutes and 51 seconds for defense remaining.
Okay. For the, let's see, defense, do you agree with that time?
Yes.
Okay, great. It is 5:20 Central Time, so we'll come back at 5:25 Central Time.
Thank you, Your Honor.
All right, are we ready to proceed to closing arguments?
Yes, Your Honor, just a couple of quick administrative matters. First, it's my understanding in this jurisdiction that the jury instructions are read prior to closing arguments, and just wanted to ensure that they were constructively done.
Sure, they can be constructively read in, yes.
Thank you, Your Honor. And then additionally, prosecution would like to reserve any remaining time left for rebuttal.
Granted.
Thank you, Your Honor.
Anything else?
Prosecution is ready to proceed, Your Honor.
Okay, we will now be hearing closing arguments from each party. Everyone should please switch back to speaker view. And Ms. Earhart, you can proceed whenever you're ready.
Thank you, Your Honor. On October 17th, 2018, what started with spilled juice and a broken laptop, it turned into yelling, screaming, turned into a beating, and it ultimately led to the death of a 6-year-old little boy, Nathan Ray, strangled to death with a belt at the hands of his own father. Now, this was a senseless act, but it was not done by a senseless man. It was done by a man who was deliberate, who was intentional, who took premeditated actions to kill his own son. And the defendant, he had dozens of decisions that forged a link in a chain of premeditation. And you learned exactly how he forged that chain. It started in Nathan's bedroom. When the defendant left Nathan's bedroom and walked down the hallway, when he got to his bedroom, when he walked across the room, when he sat on his bed, when he stopped to calm down, when he took a moment to reflect, and then when he decided to stand up, to walk over to his closet, to grab a belt, to grab this belt. And then when the defendant grabbed this belt, when the defendant walked back down that hallway, back into Nathan's room, when the defendant decided to hit Nathan with this belt, when the defendant consciously decided to grab this belt and wrap it around Nathan's neck, when the defendant decided to squeeze tighter and tighter, when the defendant decided to leave the belt, when the defendant decided to leave the belt until Nathan's body was lifeless, until Nathan was dead on that bedroom floor. Every single decision that the defendant took forged a chain of premeditation. And with each decision, with each link in that chain, the defendant could have stopped. He could have decided to save Nathan's life. But instead, he chose to end it. Now, members of the jury, we as the prosecution, we had the burden today. We had the burden to prove to you beyond a reasonable doubt that the defendant committed first-degree murder. And to do that, we had to prove two things to you. The first was that the defendant actually killed Nathan. The defendant met that burden for us. He confessed. He confessed not once, but twice. He told Detective Booth that he killed Nathan and described every single step along the way. And he also admitted to killing Nathan to Dr. Riley. The defendant met that burden for us. Now, the second element that we had to prove to you was that the defendant killed with something called malice aforethought. And you just heard from the judge in her instructions that malice aforethought, that means killing with premeditation. And you heard all of the links in the chain that the defendant took, going down the hallway, thinking, grabbing the belt, walking back down that hallway, hitting Nathan, deciding to wrap the belt around his neck, deciding to keep it there, holding it there, deciding to let Nathan die. The defendant forged that chain of premeditation. And we've proven those two elements beyond a reasonable doubt. Members of the jury, we weren't the only ones who had a burden in this case. The defense, they had a burden. They had an obligation to you all as well. And they told you during opening statements, they were going to prove it to you. It was going to be clear. And it has to be. It has to be clear and convincing. It has to be clear and convincing that the defendant has schizophrenia. That was their burden, and they have failed you. And you've heard why. You heard Dr. LaGreca come in and testify today, an experienced forensic psychiatrist with over 30 years of experience. And he told you the defendant does not have schizophrenia. He's faking it. He's faking it, and we know why. Schizophrenia, both experts agree, is a progressive disease. It happens over time. It does not happen with a switch. And that's what the defendant wants you to believe, that schizophrenia turns on and off, and that is contrary to the science, that is contrary to the medicine. An officer once explained why the defendant wants us to think that. Officer, once she told us that that switch turned on at the sobriety checkpoint on October 19th, 2018, 2 days after the defendant killed Nathan. It was only then that the switch was turned on by the defendant, and that was because he was caught. He was caught, and you heard. He was defiant. He didn't want to give his license. He didn't want to give his registration. And then Officer Wentz did something that sent him into a panic. Officer Wentz, she took her flashlight, and she shined it in the back of the defendant's car. And this is what she saw. She saw a muddy shovel. She saw bleach. She saw the trash bags that the defendant used to throw away Nathan. And that is what sent the defendant panicking. He went into survival mode at this point, and he had 3 choices: fight, flight, or fake it. Now, the defendant couldn't fight law enforcement. He was too weak for that. Flight was off the table at this point. He was already in police custody. So he had one choice left, and that was to fake it. That's when the show started. That's when the stunt started. That is when the performance started. You heard the CIA. You heard the voices. You saw the jumping jacks. And those are ill-conceived notions of what the defendant believes schizophrenia is. And that is not a switch. You heard both experts explain that it is not a switch. And that's what the defendant wants you to believe. The defendant wants you to believe that he has schizophrenia. The evidence doesn't show that. The defense failed to meet their burden. And you heard from 2 experts today. Where does that leave you? Where does that leave you, members of the jury? At best, you've got one expert, Dr. LaGreca, who tells you that the defendant is malingering. You've got another expert that tells you that the defendant has schizophrenia. At best, that leaves you at 50-50, a coin toss. And that is not clear and convincing. That is not clear and convincing evidence. The defense has failed to meet their burden. Now, the defense team, they want you to believe that there's only one explanation for why a father would kill his own son, and that's severe mental illness. You heard evidence to the contrary today. The defendant was angry. He was angry at his estranged wife, Jessica. She'd been cheating on him for months with the next door neighbor. He was angry. And just days before he killed Nathan, she told him that she was going to leave. She was going to leave and she was going to take Nathan. She was going to leave and be happy with someone else. And when Nathan spilled his juice on the defendant's work laptop, he saw an opportunity. He saw an opportunity to get back at his wife. He took it out on Nathan. That was his moment to take control, to take from Jessica, his wife, what she loved the most, to get back at her. And that's exactly what he did. He took Nathan from her. Now the defendant wants to avoid responsibility, wants to avoid accountability for the horrific things he did to Nathan on October 17th. The defendant doesn't get to decide that. He doesn't get to make that decision. Members of the jury, you get to make that decision. You get to hold him accountable. And you do that when you go back into the deliberation room and you look at the overwhelming evidence that the defendant killed Nathan with malice aforethought. And when you look at the lack of evidence to support that the defendant actually has schizophrenia, there's only one conclusion you will come to. Only one conclusion that will hold the defendant accountable and that will get justice for Nathan. Find him guilty.
Thank you, Ms. Earhart. Ms. Rivera, whenever you're ready, you may begin.
What happened to Nathan Ray was absolutely horrible. No one can deny that. The heart of any decent person breaks when you hear about a child dying so young, especially under circumstances like this. And as simple as it is to look at Timothy Ray and say, he did it, that's that. This case is much more complicated, and the job you have is much more difficult. That's because the evidence has shown you that Timothy Ray was a man troubled, tormented, and trapped in a mind overcome by mental disease. Now, the judge has instructed you that if there is clear and convincing evidence that Mr. Ray suffered from schizophrenia and that as a result, he didn't understand the nature and quality of his actions or didn't know his actions were wrong, then the law requires that you find him not guilty by reason of insanity. And as my co-counsel promised during his opening statement, the evidence has shown that Mr. Ray was a man troubled, tormented, and trapped in a mind overcome by disease by proving two things. First, that Mr. Ray suffered from schizophrenia on October 17, 2018. And second, that as a result, he couldn't understand the wrongfulness of his actions. So let's talk about that first point, that Mr. Ray suffered from schizophrenia on October 17, 2018. Mr. Ray's struggle with mental illness started from the moment he was brought into this world by an abusive, mentally ill mother. She would refuse to feed him, leave him in cold baths, and even abandon him, leaving behind his father before she was institutionalized to a mental hospital. Now, as sad as the beginning of Mr. Ray's life was, I'm not telling you about it to get your sympathy. I'm talking about it because it helps explain how Mr. Ray's schizophrenia developed. Today, you met Dr. Riley, an expert who has been a forensic psychiatrist with over 20 years experience. When Dr. Riley testified, she told you that trauma has a huge impact on a child's mental health and development. And there's no question, being abused and abandoned by your mother is traumatic to any child. Dr. Riley also told us that, like many other medical conditions, having a mentally ill parent makes it more likely that a child will develop mental health issues. And like the prosecution said in their closing argument, schizophrenia is not a switch. It doesn't turn on like a switch. By 10, Mr. Ray was having auditory hallucinations or hearing voices. By his early 20s, Mr. Ray started having visual hallucinations while in the Army. And while Mr. Ray denied having those hallucinations in 2010, we do know that he had to be hospitalized for 3 days. And just 4 years later, Mr. Ray was experiencing mood swings so severe that his wife begged him to get help. Just like he did in the Army, Mr. Ray tried minimizing those symptoms at first. But his doctor, Dr. Samantha DiGiuseppe, said that when she talked to Mr. Ray about their marital issues, he started crying so hysterically that she struggled helping him to calm down. Just a few years later, things had gotten even worse. When Mr. Ray saw his doctor again, he was disheveled and looked like he hadn't showered in weeks. He even screamed at Dr. DiGiuseppe, accusing her of listening in on his phone calls and plotting with his ex-wife against him. That decade of decline is what allowed Dr. Riley to diagnose Mr. Ray with schizophrenia. Dr. Riley didn't just pick this diagnosis out of thin air. She used this, the DSM-5, which both she and Dr. LaGreca agree is the standard for diagnosing mental disorders in this nation. And when a patient has at least 2 of these symptoms, that meets the criteria for a diagnosis of schizophrenia. But Dr. Riley also told us that Mr. Ray actually had 3 of those symptoms. Remember how he thought that his doctor was plotting against him? How he thought the CIA was after him for terrorism? Those are all delusions. One of the symptoms of schizophrenia and those auditory and visual hallucinations we talked about earlier are another. That right there supports a diagnosis for schizophrenia. But Dr. Riley also told us that Mr. Ray experienced negative symptoms like sleepwalking, poor hygiene, and inability to control his emotions, dating back to at least 2010. Nathan's mother also told Dr. Riley that he was so disturbed that he would lock himself in the bathroom for hours and would refuse to come out. She's the last person that would make something up to help Mr. Ray. Dr. DiGiuseppe and Dr. Riley both described incidents where Mr. Ray had wild mood swings and angry outbursts. He even attacked a coworker. Members of the jury, unless Mr. Ray spent the last 10 years intentionally trying to destroy his marriage, alienate his family, and ruin his life, there was no way he's making this up. But that's what the prosecution's witness, Dr. Mac LaGreca, told you. He said Mr. Ray was faking it. But what evidence is there to prove that? The fact that Mr. Ray was facing criminal charges? If that were enough to prove that Mr. Ray was malingering, as Dr. LaGreca called it, then the law wouldn't allow people like Mr. Ray to bring in evidence of their schizophrenia. Dr. Riley knows that. That's why he tried to convince you that the symptoms Mr. Ray has been experiencing for years weren't really symptoms. Mr. Ray's belief that the CIA was after him, that his doctor was recording him during their interview, those are all delusions. And if the prosecution claims they're not, then what do they call them? And why would the prosecution want you to ignore the evidence showing that Mr. Ray was a man tormented and trapped by a troubled mind? Because it means that Mr. Ray couldn't understand the wrongfulness of his actions, which is my second point. From the moment Mr. Ray was pulled over at the DUI checkpoint, Officer Wentz immediately knew something was off. Mr. Ray looked a mess and smelled even worse. When Officer Wentz asked for Mr. Ray's driver's license, she had to specifically remind him that it was sitting right there. He was also frantically ranting about the CIA being after him and seemed to be hearing people that weren't actually there. He started doing jumping jacks for absolutely no reason at all and refused to stop, even after Officer Wentz pointed her gun at him. Officer Wentz recognized this behavior and told Detective Booth. But like Detective Booth said, Even I handled this investigation like I do any other. Even after being told that Mr. Ray was acting crazy, Detective Booth still handled this investigation like any other. Then there's the shovel, the plastic trash bags, and the bleach bottles found in the back of Mr. Ray's car. The prosecution wants you to believe that they're evidence of Mr. Ray trying to hide what he had done. But if Mr. Ray were trying to hide the fact that he killed Nathan, wouldn't he have thrown them in a dumpster behind a store or at the park? Or put them in the trunk instead of leaving them in a place where anyone and everyone could see, then driving right up to a police checkpoint? If Mr. Ray were trying to hide his son's body, would he have left it in the middle of a park in Skelton for everyone to see? Given all of the evidence that was showing Mr. Ray was off, Detective Booth should have done more to look behind what caused Mr. Ray's actions. At a minimum, an investigator looking for a fair and just outcome would have interviewed Mrs. Ray about her husband's mental health history or the family closest to him. So why didn't Detective Booth do that? We know she's experienced because she's been a police officer for 23 years. She's also assigned to the homicide unit, so we know she's competent. So what is it? Well, today we learned that Detective Booth has a personal connection to this case. Not only does she have a son Nathan's age, the two kids actually played on the same soccer team together. Games on the weekends, weeknight practices, handing out snacks after the games. We all know how close you get with the other families. That's why Detective Booth couldn't look at this evidence objectively. Imagine how hard it was for her to not only find out that she was investigating the murder of a small child, it was a child she knew, killed by a parent she'd spent time on the soccer field with. That's why she insisted that she knew there was nothing wrong with Mr. Ray. It's also why she decided not to preserve the video recording of Mr. Ray's interview, because she knew that it would help prove that Mr. Ray was mentally ill. Detective Booth was out for vengeance, not justice. That's why she ended the interview by saying, "You're a piece of shit, Tim. You'd be better off dead." Between those comments and Mr. Ray's behavior, there was no way Detective Booth was going to let that video see the light of day. That's why she let that video be destroyed. Now, members of the jury, in a moment, the prosecution is going to get to speak to you again. One last chance to answer all of the questions and concerns we have left by their failures to conduct a thorough and unbiased investigation. And when they do, I want you to ask yourselves if it makes sense when they tell you that Mr. Ray was not going through a schizophrenic episode when he killed Nathan, when the evidence shows otherwise. Listen closely when they tell you why you should rely on Dr. LaGreca, even though his opinion ignores important facts. And pay close attention when they tell you that Detective Booth was the right person to investigate this case.
Time.
And because of that, you know that you will find Timothy Ray not guilty by reason of insanity.
Thank you, Ms. Rivera. Ms. Earhart, rebuttal, if a time check can tell me how much time Ms. Earhart has for rebuttal. You guys might be calculating, but did you hear me for the time check?
Sorry.
Yes. 1 moment.
We have
Okay,
3 minutes and
no problem.
seconds left for rebuttal.
Did you hear that, Ms. Earhart?
I did not. Can I get that one more time, Taryn, please?
3 minutes and 47 seconds.
Thank you.
Whenever you're ready.
Thank you, Your Honor. Members of the jury, the defense threw a lot at you there. There's really only one thing I want you to focus on, and it's something that the defense didn't talk about much. The alternative here. Now, the experts told you that the defendant doesn't have schizophrenia and that he's malingering. And the defendant wants you to believe that he does have schizophrenia, but let's assume for a second that he does. What the defense didn't prove is that the defendant didn't understand the consequences of his actions. They want you to believe that it was some foregone thing, that he just tossed a body somewhere. That is not the case. He took a shovel, took bleach. He took trash bags to conceal the body. He went deep into the woods of Brandywine State Park. He buried the body in the ground. He didn't tell anyone that he'd killed Nathan. He rode around for days with that body. He hid that body. It was a cover-up. He understood the consequences of his actions. And he didn't turn himself over to law enforcement. He got stopped at a random sobriety checkpoint, and that is when he got caught. That was when his plans unraveled. That is when he was caught red-handed. That shows he knew what he was doing. The fact that he didn't want to give his license, that he didn't want to give his registration, that he was defiant, that he was squirrely by Officer Wentz's own testimony. It was a cover-up, and he got caught. And that shows that even if he was suffering from a schizophrenic episode, which the expert tells you he wasn't, even if he was, he still knew what he was doing, and the defense still didn't meet their burden. And that means when you go back into the deliberation room, there's only one clear choice. That's that the defendant is guilty.
Thank you, Ms. Earhart. Judges should please complete their ballots. I'll ask everyone to stay on until everyone has submitted their ballots, and then we'll do brief comments. And judges, just when you're done submitting your ballot, you can just chat or appear on the screen. Either one is fine. We can do comments. Yes, you guys can relax. You did it. Third round done. I know it's been a long couple of days.
Seeing the dog was a nice way to end the day, for certain.
We're just waiting for one more juror, and then we'll get going. Oh, 2 dogs now.
Do we have names?
This is Ziggy the dog.
Ziggy.
This is, if I say her name, she'll probably jump up again. Stitch.
Love it. I love all the dogs I'm seeing.
Oh my gosh, I do too. I'm sad that I don't have a dog in here.
I thought she was going to testify for a second.
Okay, all the ballots have been submitted. We will do some brief oral comments now for the attorneys only. Because we have so many judges and we want to give the attorneys time to prepare for our next trial, or for, in this case, finding out the results. I will ask each judge to limit themselves to one comment, either their favorite moment from trial or one suggestion for one of the competitors. We can start with Juror Finkelstein. You appear first on my Zoom, so you can start.
Okay, I have seen many mock trials in my life at all different levels. I honestly believe this is one of the best I've ever seen. And Juror Padilla was with me yesterday, so she knows that I don't say that every time. I thought it was clean. I thought there was an obvious strategy that was being employed. And for the most part, that strategy was in everybody's mind, forefront all the time, and the objections and the arguments and the testimony elicited was for that strategy. My one little constructive piece of feedback is very, very small, and it was very minimal, but I do think there was a little bit of an impulse sometimes to do that sort of mock trial tick where you go for some easy issues at the beginning of a director cross-examination that were sort of like, yeah, they're in the problem, but they didn't really seem central to your theory. But then once you got rolling and you were really in the questioning, you were very much on theory. So the time is really short. I'd rather see you get in and out and be effective. Just don't give in to that impulse to like slow warm up on things. You know what I mean? I'd rather just have you like precision surgical, like get in and start cutting. And I think that all of you were doing that once you were rolling in your questioning.
Jerry McManus?
I just want to say great job, everybody. Both sides, when you're going to ask cross questions, just make sure you know the answer. I think that happened with both sides where you're a little surprised. I'd like to see more of a clear and continuous theme from both sides being present in the opening, the closing, the directs, and the cross, just a little more, just hammered in a little more. Prosecution, great discussion of malingering. I've never even heard of that, so I liked how you presented it in a way that anyone can understand it. Great use of the photos throughout the case. In addition to showing what the photos are showing, such as the belt and the shovel, you're showing this poor child's like toys or his car seat. So great getting that in. Excellent, Jordan, excellent pacing, tone, and inflection in your cross. Well done. Defendants, good discussion of this missing video with Detective Booth. I like the phrase in the closing, troubled, tormented, and trapped. In the closing, that was good. And good getting out that your expert actually interviewed the defendant and other people in this case. But overall, both teams very impressed with how professional and prepared and how well done how well everyone did. Good job.
And Juror Padilla?
Hi, good afternoon or good evening. Thank you all. It was my pleasure to participate with everyone here today. The judge asked for very brief comments, so I will reserve them for two quick ones. Mr. Mills and Mr. Hulsberg, one of my two favorite parts of the whole presentation is when I swear, like the two of you were really at it during the prosecution's case in chief, and I thought you were both excellent. That was only matched by the closings by Ms. Rivera and Ms. Earhart, who made me feel like I was watching a tennis match and made me feel like I really was at trial, and I wanted to hear from them. So to echo Ms. Finkelstein's comment, it seems as if you guys were really listening to each other, and that showed. And just one more message, jurors pay attention, and they're going to be paying attention to not just with the words that are coming out, but how you present. And it was clear that you were all very attentive to what the other person was saying, which I thought was very effective. And if I may, just a point of privilege, as a military officer myself, I value patriotism. As an attorney, if you are presenting in a civil environment, you might just want to be a little careful about the pin, which, you know, for those of us in the military, you know, go and then but you have to remember you're there for your client. So we don't want to mix too many messages, but thank you for your service and thank you all. Great job.
Yes, I echo all three of the jurors' comments. All four of you are going to be great trial attorneys. You have great presence. I am like more than certain that if we were in a real courtroom that you would just be captivating throughout the entire trial. Just two of my favorite parts was one, Ms. Earhart's rebuttal I thought was fantastic. And two, Mr. Mills, your cross-examination, you had quite a difficult witness, and the way that you kept your composure was really, really impressive. He was being quite difficult, and to a point where I almost intervened, but I wanted to see what you were going to do, and you did not disappoint. So good job. With that, everyone, the comments are done, and you guys can sign off the Zoom. Good luck to everybody, and I wish you well if you are advancing.
Thank you.
Thank you.